Well, many thanks for all of you that you have decided to stay after a very long and a very productive day. I think the main idea behind this panel is, instead of having these formal presentations and commentary, to have a more free-flowing discussion, that our panelists will be able just to make comments on a number of topics, which I will identify in a moment. So it's a more relaxed, more free-flowing discussion now. You may have noticed already that there's a discrepancy between the number of the speakers or the panelists that are here and what is written down in the program. We're missing Mr. Petrochilos. Mr. Petrochilos had, the ambition of having the unique distinction of being present at the same conference, both through video conference, but also present in flesh. He wanted to come at this late stage, but he obviously failed to do that. So we have 3 rather than 4 commentators, which is going to be a blessing in disguise, in the sense that we will be shorter for all of you. Now, the 2 topics of our panel discussion today is, first, institutional innovations in international arbitration, and secondly, the proliferation of international commercial courts and court chambers, whether they can challenge international arbitration. Now, the idea behind the first topic is to discuss a number of significant procedural innovations that institutions mainly have devised in the last decades to address some of the criticisms, some of the needs that practitioners had identified as potential issues. The idea behind the second topic is, you may have known that in a number of national courts have now developed some specialized international commercial courts. The idea came from Singapore first, then we have a number of others in Kazakhstan, in Abu Dhabi, in Dubai, and they want to attract some of the commercial disputes and have a more flexible, more party autonomy-driven format, rather than deciding disputes on the basis of the civil procedures. So again, the idea is to attract more disputes there, rather than allowing them to go to arbitration. Can they actually take material from the arbitration, from the tribunals? That's what we will be discussed. The 2 topics are carefully chosen, I have to say, to draw them on the collective experience that we have in the panel today, because we have the pleasure of having both Nordli and Alex, 2 individuals who lead in different ways the most popular and established arbitration institutions, the ICC and the LCIA, or the LCIA and the ICC. And at the same time, in Christoph, we have the views of a very experienced practitioner and academic. In terms of the format, I will just throw in the topics and then we'll take comments in turn from our panelists. So unless there's any other comment, maybe we can start, starting from the first topic about the response that institutions drove to respond to the challenges and some of the criticism that arbitration has been through, rightly or wrongly, in my view, often wrongly. And I'm referring here on a number of procedural devices. And I want to start to take them in turn. I need to start from emergency arbitration. Who wants to take the lead about why emergency arbitration, how was emergency arbitration came about, and whether it actually has responded to some of the needs of practitioners? Alex?
Sure. Happy to take that. Thank you, Stavros. One caveat, I think when we speak about innovations, it sounds as if everything is, the wheel has been reinvented yesterday. I don't think that's true, and I think we should say that and get it out of the way from the start, and hopefully my colleagues will agree on that. So there is innovative approach, definitely, and there's change, and there's a dynamism, I think, in the work that is done across institutions and outside of institutions as well. But it's not something, we're not really speaking about something that revolutionizes a system from one day to the next. And I think emergency arbitration is actually a good example of that. We do speak about it today because it's very successful, but there have been many attempts towards fast-track adjudication of interim relief in different forms for some time now. Previous iterations of the ICC rules, for instance, had included a system called the pre-arbitral referee, which envisaged on a slightly different philosophy, a similar goal, we still get the odd arbitral, pre-arbitral referee case now and again. I think we've had a total of 15 or 20 cases over 25 odd years. In less than 7 years, by contrast, we have received more than 100 emergency arbitration cases. Which is why is that necessary today, and whether that responds, at least in the context of the ICC universe and of some other institutions as well, whether that really facilitates a specific need. And I think it does. There is a need to proceed with a rapid determination of the need for some urgent interim relief ahead of the formation of an arbitral tribunal. Now, there is no monopoly on the forum before which parties can today appear before to receive that form of, potentially receive that form of interim relief. You may go before a state court. You may go before a dispute adjudication board if you're within a construction dispute, particularly a FIDIC instrument. You may go before an emergency arbitrator. And none of those seem, at least, and there are many caveats, but I'm simplifying, none of those are excluding the others. And that is where I think the room for this blooming of emergency arbitration came in. Does it respond to a need? Yes. You can get, for instance, under the ICC rules, you can get a decision by way of an order on relief that is so urgent that it cannot await the constitution of the tribunal within 15 days as of the appointment of that one person. Within those 15 days, the emergency arbitrator, who is, as with any arbitrator, someone who is selected on the basis of experience and obviously here an enhanced level of availability, will need to determine that relief by inviting submissions, sometimes holding hearings, sometimes asking for further submissions, and by drafting an order within that time to dispense or discharge with that relief. So yes, it does respond to a need. And certainly in some types of disputes more often than on others. And it is a mechanism that has been efficient in that very often it carves out issues which may ultimately even lead to the settlement of the dispute, or at least flesh out certain issues on which the first phase of the arbitration to follow will be important. It is quick, and it is.
Can you just, for the benefit of the audience, explain how quick it is? I mean, what is the time frame? So I think it's important to.
Well, usually what happens is that by around 7 p.m. or 10 p.m. on a Friday evening, or on the 24th of December, or on Good Friday, the Secretariat of the ICC Court or any other institution gets an application saying, there is this bridge that is being built, we are facing delays, they are going to call in the bank guarantee on Monday, please, help us get an emergency arbitrator in place so that, there can be some sort of injunctive relief put in place immediately. So basically the institution has anything within 24 to 48 hours to react in making, if you like, a prima facie determination on the applicability of that emergency arbitrator setting. And usually you need signatories. You cannot rely on extension theories or direct successors to the signatories of the contract. You usually don't have retroactive effect of the emergency arbitration provision. So all of that is vetted very quickly. At the same time, the institution is looking for suitable and available candidates.
Candidate that can accept on a Friday or on a Saturday.
Exactly, and you'll be surprised, but there's plenty of people who will be available on Good Friday or over Eid or over Ramadan or over Christmas. It does happen. Or
sadly, yeah.
Well, yes, and then the file is transmitted to them as soon as they're appointed, and then the ball gets rolling, and it usually stops.
So it's 15 days. That's the
under
other
the
thing.
ICC system. Yes, I think there's different systems under different institutions. Yeah.
Audley, how does your experience in the LCIA compare to that? I mean, both in terms of the time frames, the need to do that. I know that you came. And the popularity of the system and the LCIA.
I think our experience is slightly different from the ICC's, and the last revision of the rules allowed for emergency arbitrators. The LCA rules already provided for expedited formation of the tribunal in exceptional circumstances, and that bar was fairly high to be able to meet that. But in the situation that Alex describes, where a guarantee is going to be called on Monday, or situations when I was vice president there was going to be a board meeting and they were going to do something with the shares, or they were going to call in a liquidator or something, and something had to be done. An expedited formation of the tribunal, whilst expedited, could still take some days. So there were calls for emergency arbitrators, notwithstanding the parties could go to court and get similar or better relief with the police powers of the court. But nevertheless, it was thought that, particularly in England, that could be very expensive, and the whole infrastructure of having barristers and whatnot doing that wasn't attractive. So we brought it in. But our difference from the ICC is we have found that it's not used that often by the LSA, which is surprising because people were fairly, it cost a lot of money, but people were not put off from going to the courts for ex parte injunctions, yet they don't seem to be availing themselves of availing themselves of emergency arbitrators in the LCIA, and at similar time periods as that which, as Alec described. If I can just sort of segue as to what we find there is an interesting demand, although I think what is talked about and what happens in practice is perhaps is a slightly inconsistent, and that, of course, is around time and costs, and to have faster, quicker determination, and as a result, cheaper determination. And the Law Commission, which is a body government set up, which is to look at various aspects of the law and to advise the government where the law could be modernized, reformed. And it's not a political issue, it's just improving the law. And they looked at the Arbitration Act, and the general view was that if it ain't broke, don't fix it, although it could certainly do with some modernization. But the one theme that kept coming back was what the English call summary judgment, early decision, really where the respondent, the defendant, has no defense. It's not the situation where the defendant fails to put in a defense, fails to appear, and then you just, in court, you would get judgment in terms of your relief, no matter what, almost whatever it was, as long as it didn't defend public policy. But summary judgment is where the defendant does turn up, but they've got such a bad defense that the court will decide it on a summary basis. And that was the thing that users, particularly corporate, said, we want. We said, or the community said, it's already there. A tribunal can do that. It already has the powers. We'll give them backbone. Now, I don't think the Law Commission is going to take forward a change in the Arbitration Act, but the LCIA is in the process of updating its rules. It needed to do it because of a change in the way it holds money from a trust relationship to a creditor and debtor relationship. But we took the opportunity, and what we have introduced expressly is the power, but the power already exists. So really the encouragement in black and white terms for tribunals to make an early determination where appropriate. If anybody's familiar with the ICSID rules, there's something similar there for really where the respondent has on the face of it no credible defence. It may turn out that it does have a defence, but to encourage tribunals to make an early determination if they can. That's not in yet, so we'll wait and see whether actually seeing it in black and white changes behaviour of tribunals.
Christophe, in your experience, have you had the opportunity to act as an emergency arbitrator?
Well, in fact, I wanted to react on this very point. I'm a member of the Swiss court, so we have also the emergency arbitrator, which is fairly successful as well. But the problem we saw is to find good arbitrators. You mentioned twice availability. I have been asked several times from the ICC. I could accept, I think, once. Because it's very, and we tried to establish a list of potential arbitrators for under the Swiss rules, and you won't find the usual suspects on this list. You have younger practitioners, which sometimes is a problem, because even though it's a prima facie determination, there is huge time pressure. You are alone. It's more difficult to respect the equal treatment of the parties. You have to get to the decision within 15 days. There is no extension. And it's difficult to get the best arbitrators for this job. People who just can drop everything and devote 15 days to one single case.
I think you're right. If I may...
Be interesting to know what Alex's experience of that, because when we did it, I think we had sort of 15 on a list, and it was only the 15th, because you've got to clear conflicts immediately. Yeah. It was about the 15th that could do it.
But what is interesting in this process is that parties are actually very collaborative before the process begins. So very often when a dispute is brewing, you will get a party making a completely confidential call, of course, to the Secretariat saying, hi guys, we're thinking about filing and it may come in 2 days' time. And there we will ask, we don't want to know anything that we don't need to know at that time, but we will ask certain questions that will be helpful in making sure that we already start thinking about the right skill set of the emergency arbitrator. And then, of course, the beauty of institutional input is that you can take benefit or whatever little time frame you have to start thinking about names and even vetting availability. Obviously, you can't vet conflicts until after you get the case and you see what it is about, but you can at least say, hey, are you available over the next 20 days or so, or are you available? And there, I think, you ultimately get, after many rejections, that's true, you will get to someone from within that list that you will have compiled that will accept.
We had one of the most senior, well-respected members of the London arbitrator community did one for Stockholm. He just found it so horrendous, the demands on his time in a very short period of time. He said, never again, and actually was trying to discourage us from offering it at all, because he said it was so difficult, actually. Say, let parties go to the court.
We should remind that the Stockholm Chamber of Commerce demands 5 days for the procedure, the emergency arbitrator order to be out, which is a very, very tight time framework.
If I may, just one point that Christoph raised, I think those cases should not, emergency arbitration should not be seen as sort of like the springing board or the jumping board for the the ones who are, new to the church. It's something that actually requires stamina, coolness, and experience, procedural and substantive. And I think that is why you actually get sometimes even very senior figures in terms of, arbitrator work who sign up for those cases. And that doesn't mean, of course, that you don't have less seasoned practitioners. There are cases for them as well. But it is not the traditional segue for someone to break into arbitrator work.
I think you're absolutely right. I think you're right to identify that the very tight frameworks and the availability is a challenge there. May I add, from my personal experience, having done one under the ICC and one under the LCIA, another, I think, point that needs probably more guidance and maybe a better understanding on the part of the parties. What are the thresholds, the standards for the emergency arbitrator to grant the requested order? It's not whether there is urgency and potential harm. That's for the typical interim measure. Very often the parties say, if you don't grant me this, I'm going to face harm. This is not the standard necessarily. The standard is, are you going to be faced with this kind of harm until the tribunal is going to be formed? The emergency arbitrator has a very time framework, not only to issue their decision, but also until when to do that. If it's something that can be done by the main tribunal, then you don't really have this authority. And I think that's something that the parties were very difficult to understand. So I was wondering, in your experience, whether the majority of the orders requested are actually granted or denied, and whether that has to do with the applicable standards, if you can make such a generalization.
I think there's three main issues here, and substantive standards is the third. I think the three main hoops that an emergency arbitrator usually needs to go through, and they're not an easy task, are jurisdiction, admissibility, and then substantive standards.
Right.
And those matters are contrasted, I think, from the way that we are used to knowing them in the context of state-ordered interim relief or arbitration tribunal-ordered interim relief. So, focusing on the third, at least under the ICC rules, I think you're very right. Article 29 of the rules says that this is available for relief that is so urgent that it cannot await the constitution of the tribunal. Now, in my view, that is the standard of substance that needs to be guiding the emergency arbitrators. Now, there is difference of approach. You know, you will have parties and ultimately emergency arbitrators who will plead domestic standards or model law standards or standards under international regimes. Ultimately, I think this type of very urgent urgency is the one that is more guiding. There's a recent report by the ICC Commission on Emergency Arbitrator Proceedings, which is available online, and on which other institutions actually have also contributed their own experiences, which I think points towards that direction.
Christophe, sorry.
No, I'd agree with Alex. It's holding the ring, really, isn't it? Because something would change even if you had an expedited formation of a tribunal.
Christophe, in your experience, any challenge that you had been faced with? You said you acted once. And what were the main challenges when you acted? I
think these are the three main challenges at the beginning. Jurisdiction is a big issue.
Let's move, if there's no other comment, let's move to the expedited procedure, which is something that is a certain time of 6 months. I think the ICC has it. And maybe we want to contrast the LCIA, how they...
we won't have I don't think we're going to have a time limit.
Okay.
Expedited faster than otherwise.
And how, do you want to give us, the background of whether there has been discussed in the latest revisions, or what was the thinking, and what are the alternative ways of, LCIA deals with this?
Well, as I said before, I think that power has always existed, and I'm sure the audience has, well, why don't arbitrators move things along faster, be a little bit more dictatorial, a little bit more prescriptive of what they want when they want it? And are the parties not actually encouraging their lawyers? Shouldn't the parties be on the back of the lawyers saying, no, we want you to move this faster. I don't care if you're doing another case, get on with it. And so the parties should be in the room when timetables are fixed. But somehow it's really happening. Somehow even the parties then agree, when I said as an arbitrator, I think, well, that's a bit leisurely, isn't it? But the parties have agreed, and is it really your position to say you've got to do it faster? If somebody's wants to move it along very fast, somebody is clearly dragging, the respondent is dragging its heels, well, then you can move it along. But what we wanted to do, and I think all institutions want to do, is, as we have done, and you do, what can you do? Is you can do things in respect of the timetable, but can you do more? Can you identify from the early documents a request and an answer? What are going to be the key issues? Can you actually prescribe only address those issues, or can you say, well, we think we'll be most interested in that? And I think there is a bit of a siege. I think more and more tribunals are seeing a list of issues, an early list of issues, being very helpful, because then, even if you do it after the first statement of case and defence, that can then be the hook on which you make decisions on document production, on which witness statements comment, and on which experts' reports opine. And I think that helps. And I think it's coming forward at an early stage and giving that direction. we could have a debate about whose arbitration is it? Is it the parties or is it the tribunals? I believe it is still the parties' arbitration, and if they want to go slow, they, as a practicing lawyer, my day job as a practicing lawyer, they may have reasons why they want to go slow, and the tribunal should not intrude on that. But if somebody is holding on to the handbrake, then they may need to help that. But what we've tried to do, and the institutions generally try to do, is what can you do? What sort of orders can you do? And we as an institution are giving institutional support for either preliminary issues, albeit what I said, you know, there is some reluctance sometimes to decide preliminary issues, although that they would certainly get rid of some claims or focus the debate, but do that and give indications as to what you think are the most important issues.
Yeah, I mean, we'll come to Alex to describe how successful the expedited rules for the ICA has been. But before I want to take Christoph's view and pick up on a point that Audley made in relation, all right, let's find the tribunal should find some ways of expedited procedure. And in your capacity, I mean, in your experience as an arbitrator, what do you usually do? I mean, as Audley said, whose procedure is it? Is it the parties? Is it the tribunals? How do you do if you see a party just to be very reluctant to proceed in an expedited way?
Well, I think as Audley said, the first thing is to see whether both parties want to go faster, or only one, or none of the parties. If none of the parties wants to go faster, then it's okay, it's their case, and I mean, you can push for going quicker, but it's difficult to impose time limits the parties don't want at all. If respondent is dragging its feet, then you can push a certain pressure on respondent to play the game. But I think it's there are two problems. The first, as you said, is to get the parties to the initial meetings, because if you ask, sometimes it's really disturbing. If you ask claimant how much time do you need for your statement of claim, and then they open their huge diary and they tell you that the first possibility would be in 6 months. If the party hears that or sits beside external counsel, I think the answer would be different, because otherwise the client would feel where its case is in the list of priorities of its counsel. But I think another problem is also that arbitrators should get much earlier in-depth into the case to see, to identify possibilities where you can go faster, where are the real issues, where should you focus on. But in my experience, too many arbitrators just set up the case and then let it go calmly. And one day, as someone said this morning, you have to write an award. And then, before the hearing, you get implicated. And then again, before you write the award. That's not how it should be.
Right. Alex, your experience, the institutional experience, so how successful the expedited procedure have been?
Yeah, I think so. Under the ICC umbrella, things work a little bit different in that we have expedited proceedings applicable now for about 2.5 years. They apply only prospectively, so only for our claims that are being brought under arbitration agreements that entered into force after the expedited procedures entered into force, and they apply where the overall amount in dispute is up to $2 million, and they apply automatically. So if parties do not want that, they need to explicitly opt out. Now, so far, given that usually a contract requires 2 to 3, sometimes even 4 years to bring up a dispute that will be submitted to ICC for resolution, we are now seeing a steady flow of cases. I think last year was 30, we're already at an additional 50, and obviously this is going to keep on growing. What is interesting is that we've seen more requests to opt in, therefore situations where the monetary claims were above 2 million or the arbitration agreements predated the rules themselves, where the party said, we want into this, and then there was no agreement, and as no agreement, they didn't apply. I think there is a common misconception with regard to the public at large, with regard to what expedited arbitration means. And it's not fast arbitration. It is not the same process that one is accustomed to in what one, in abstracto things an arbitration is, condensed into a shorter time frame. Expedited arbitration is something that takes into account the realities of a case and whether those realities would fit a different time frame and a different procedural menu, if you like. So we put the threshold on terms of money at 2 million, looking at the overall division of sizes of cases that we see in ICC arbitration. For a number of years, about 25 to 30% of our caseload had an amount in dispute of up to 2 million. We then have, of course, cases up to the mega billions, but obviously those will not go to expedited arbitration. Yeah. And we thought that those cases, to the extent that they are not complex procedurally or substantively, can be administered on a basis that will lead to an award within 6 months from the case management conference and will cost 20% less, because there's a different fee arrangement. So there is an incentive for arbitrators and there's an incentive for parties. It is therefore a win-win. And of course, an institution, I think, is also not completely detached, if you like, from having an interest in that. In the Queen Mary study, institutions were signaled out, the latest one, and I think the previous ones as well, as accelerators of change. At the same time, an institution has an interest in being reputable and efficient in the services it provides. So we feel that there is room for that, and we see that that room has now been created, and it works well. No words have been set aside, which is always good.
Christoph, you had a comment on that?
We have this as well under the Swiss rules now. We have had it for almost 10 years now. Threshold 1 million, 6 months as well. And it worked well. And contrary to the emergency arbitrator, this is a means to get new arbitration practitioners into the market, that they can make their first experience with a small case, a rather easy case, still with the time pressure, but they can get used to arbitrations.
And this is one of the things, and thank you for raising, I think this is one of the things that gets me quite fascinated with expedited arbitration. It is really a vehicle that can facilitate the resolution of international trade disputes between medium-sized and small enterprises as well. It is something that expands the pie, where arbitration can then be seen and identified by non-arbitration savvy practitioners or users as an attractive means to settle your disputes.
Right.
And I think it falls very well within this day and age where we've moved from very standardized to less standardized solutions in dispute resolution.
More bespoke.
Yeah.
Moving, I don't know whether the audience has any comment or any experience that they want to share with us. I mean, we'll do it later, I'm told. Then let's move to another innovation, this time coming from the LCIA, the rules and the ethical representation. There's been a very big discussion in international arbitration about the different levels of ethical obligation for counsel when appearing before international tribunals. Just to set up the ground, if a counsel appears, let's say, from Greece, he or she is bound by the rules of their bar association here in Greece. However, another counsel coming, let's say, from the US has different ethical obligations or different obligations coming from their own bar. And in a number of different things, can you interview your witnesses before? To give you an example, in relation to document productions. So the questions that has come up very briefly is whether there has been some discrepancy in the terms of the obligations of different counsel appearing before an international tribunal, but this counsel coming from different jurisdictions and different bar associations. And the LCIA introduced in 2014 for the first time some ethical obligations. And Uli, I mean, can you please describe, how they emerged, what was the thinking behind it, and how they work in practice?
Yes, certainly. Thanks, Stavros. And I think, Professor Kouros, you've got a topic for next year's forum. So I won't say anything if I want to be invited back. It was an issue du jour at one time. And there was, despite some of the topics that you mentioned, there was a feeling that there was not a level playing field. Another classic example is to what extent can lawyers, let's call it, although it's slightly pejorative, coach their witnesses before they give evidence. And it was thought that, rightly or wrongly, American lawyers could do more than certainly English lawyers. I expect the same here. And that was one issue that was going around, and whether if you cannot level the playing field, you should at least know what other people can and can't do. The other one was a growing disquiet that tribunals had no express power to punish counsel misbehaviour. And these things came together, and they got a bit of a heft by one Sundaresh Menon, the Chief Justice of Singapore, in ICA, was it? In Singapore?
It was
Singapore. Well,
said. Not in Singapore.
And, you know, he's a very notable commentator, and he has the authority of a Chief Justice of a rising arbitration seat, that if the arbitration community did not regulate themselves, somebody else would, and that may not be good. That coincided with the what's it called? The Council, the Bar Council of the European Union, but it's CBB something or other, came out with rules, and there was a fear, certainly in England, which is, of course, very topical. Was thinking if something wasn't done, then the European Union would come along and regulate arbitration, and that would not be a good thing. So the view was taken. Johnny Vida was very keen on it. I was not so keen on it because I thought, you know, how can you really articulate regulation that isn't sort of mum and apple pie about you should do nothing naughty? Okay. I took some soundings, and some very eminent arbitrators said arbitrator misbehaviour is a real problem. Of course, it's not commonplace, but when it happens, it's really bad, and we need the power to be able to criticise. We can do it in cost, but that's a punishment against a party. I mean, we need to be able to say something and reprimand counsel. So we introduced it, and one of the other important aspects is that a party can't change counsel and thereby give rise to a potential conflict. So tribunals are now allowed to stop change to that particular counsel if it could affect the integrity of the proceedings. So these things were brought together and introduced. It also coincided with what the IBA was doing, and its enthusiasm to bring out regulation brought out its own parallel rules. The regulation of lawyers is incredibly important, but and any law firm that is doing an LCA arbitration is meant to have said to anyone that is working on the file, these are the rules, and we have to comply with these rules. You know, which is not a particular problem when that's what you do kind of all the time. As a slight admission against interest, I'd probably say they've slightly risen without trace, because I think, as I said in my introduction, it was an issue du jour. Ethics is very important, there's no doubt about that, but it's not, I don't think it's getting the noise that it did back around that time we did it. Has that noise quietened because of what the IBA has done, what we have done, what tribunals and ICC and Swiss and Swedish arbitrations are doing? Maybe that's the answer. Are counsel behaving themselves better because they feel tribunals have been empowered one way or another, expressly or just generally, I don't know. But
have you seen it?
I don't think I don't think it's a topic of discussion in very many arbitrations.
Fair enough.
To be honest.
Fair enough. Christophe, I mean, in your approach, both as an arbitrator, whether you wanted to have this kind of teeth, backbone, as Audley said, to enforce some ethical obligations if one of the counsel was misbehaving. Did you ever find there? And why do you think Swiss rules never adopted a similar position?
No, from my personal experience, I fortunately never experienced a situation where I would feel the need for this possibility. From a Swiss perspective, I think the majority of arbitration practitioners is rather critical. And I think, again, you as an arbitrator have to sense, to spot, to identify potential ethical biases, I would say, because you have different cultural backgrounds from both parties, and you have to bring up these questions as soon as possible to clarify them, not when the problem arises, but beforehand.
So do you do it in advance? I mean,
of course,
do you?
of course.
Okay. In what form do you raise it with the parties?
During the case management conference, if we speak about the hearing, if I sense that one party is much more, or one counsel is much more experienced than the other one could try to be very faithful to his civil procedures, so no contact with the witnesses, but the other one is an experienced arbitration practitioner, so I would bring up the question just to clarify and play on the same rules.
Alex, I know that this issue has been discussed in the ICC extensively, and eventually you decided not to adopt any similar procedure. Again, if you want, to the extent that you can, elaborate on thinking behind it.
I'm very pleased that I think Audley explained it very well, even for myself. I would share his view that I don't think that there was necessary. I mean, there was an appetite, but I actually wonder whether that was sort of like an appetite du jour, which kind of like faded away. I think it's still an important issue. Obviously, ethical conduct is something that remains largely self-regulated outside the context of rules or even concrete guidance, because we have not seen many examples of the application of the IBA guidelines on party representation, for instance. We don't see much of that being recorded. I don't know if there have been any incidents where the appendix has been used or cited, at least it has been used. So probably there is experience, but it's not ripe for sharing.
Do you have parties complaining to the ICC that the other party has been opposed appallingly?
Well, oddly, very oddly, very exceptionally, you sometimes hear in one or two cases, well, my wing consulted with, the other wing consulted with the other party on this, that kind of thing, or, witness prepping. But I think usually an arbitrator does have, I think, an obligation to make sure that a certain level of common understanding will have been reached on what should be discussed with in priority from the get-go, and I think that's important. I am also probably a minority in thinking that arbitrators already possess inherent power to sanction, so to exclude counsel if they have to. That's something we've seen in exit proceedings. It's something now that, of course, is included in some institutional rules. We see arbitrators asking parties to agree to that power in terms of reference. So there is development in that. And I should also say that maybe one recent point where we may see potential development of ethical conduct guidelines is ISDS, because now, as you know, our friends at UNCITRAL, all the states that take part in UNCITRAL, are now discussing the potential use of a code of conduct. So let's see, maybe that topic is now going to be rekindled.
Just moving now to the final innovation, or not innovation, I just think an innovative approach, as Alex suggested, the provisions for publicity of awards by default, but basically the sanctions for late awards being issued. And to what extent, again, what was the thinking behind it? Whether you think is a good idea more generally, whether do you think that there is an issue in arbitration of late awards, and whether there are, different range of options to address this issue. Do you want to start, Alex? Because, you know, the ICC introduced the sanctions.
Yeah, I mean, it's, I would focus more on, I will speak on sanctions, but I think duration of proceedings is important. There are different ways that one can use metric and different ways in one can approach that. I think it's important when we go into that discussion to always be conscious to compare apple with apple and not apple with orange. So in the context of an ICC, of the ICC caseload, again, you have disputes with very experienced parties, with inexperienced parties, with experienced and efficient counsel, and completely inexperienced counsel, small cases, big cases, different applicable laws, different court interventions, multiple places of arbitration. So it's an extremely dynamic and diverse pot. Now you need to instill some sense of continuity, of identification of a common thread in all those arbitrations, and that also translate in a common philosophy behind when should an award finally be rendered. So obviously a rule can always and must always have its exceptions, and those need to be, that needs to be acknowledged. There is a rule, which is a rule of practice today, that arbitrators should in principle have finalized their draft awards within 3 months of the last substantive submission or the main hearing. If it's a 3-member tribunal, 2 months if it's a sole arbitrator. Now, again, this is a practical rule which will know and does no exception, because there are matters of complexity. There may be a huge dissent that should be avoided. There may be novel issues that can only come up during deliberations or during the post-hearing briefs that are completely novel and may require further assessment and briefing. There are a lot of different ways that this rule can be broken, if you like. But there are many instances where this rule should not be broken. And I think that is where availability of arbitrators now is something that is truly seen, not just at the outset, but during the life of the case and ultimately at the very end. And an arbitrator, busy as he or she may be, should not be seen as taking hostage a whole process on which parties have invested time and money. And that is where the sanctioning part comes. So if you're late, you will, and that delay is not attributed to party conduct or other extraneous circumstances.
You will be punished.
You may be sanctioned. You may also be uplifted on your fees if you do it quicker.
How often have you uplifted fees?
Well, that does happen.
Have you?
Oh, yeah. Okay. Very often.
Christophe, I'm not going to dare to ask a Swiss arbitrator whether they're late in delivering the awards. But do you think it has made any differences in the ICC cases that you have dealt, whether you have an urgency now or your fellow co-arbitrators that have a more urgency to deliver the award more swiftly?
Yeah, I think so. We were not, at the beginning, not very happy about these new rules, but I think they are perfectly justified, and they put the necessary pressure on us to move the cases up in our list of priorities. And
have you asked for an extension?
I don't think so.
Early?
We don't apply sanctions, albeit there's a reputational sanction, but I think the ICC development concentrates the mind, and as long as it's applied fairly in the way that Alex has described, I don't think it's a bad development at all.
I'll just very briefly move to the second topic, which is going to take much less of our time, not least because it's more broader and more general. I mean, there has been, as I mentioned, arbitration being the subject of criticism for a long time. Now, we discussed the areas of how arbitration has responded to that. There has been, however, another parallel development, which is the development of international court tribunals. Do you think that they represent a threat to international arbitration, or in the future? What do you think, Audley? Do you believe that there is any potential for them to somehow develop to a credible alternative to international arbitration, commercial arbitration today?
No.
That's the end of the question.
I think possibly the commercial court in Singapore.
Why?
Might, because of the thing I can say in this sort of, the relative lack of alternatives in Asia. for international disputes. And traditionally, it's been, well, not even traditionally, traditionally Hong Kong. Singapore has done great work. The ICC is represented there. But after those three, and goodness knows what's happening in Hong Kong at the moment, there isn't that much choice. So, they're three good alternatives, as well as others. The LCA does a little bit over there. But the parties probably are not that keen to go to any of the national courts for cross-border, but they may they may think Singapore is because Singapore is, I wouldn't say it's unique. I mean, I know it's described as a Switzerland of Asia, but it has that differentness. It has a different quality to many of the other countries. And because it's such a trading nation and not a lot of disputes are particularly Singaporean, I think the good commercial court there might attract work that might have otherwise gone to one of the institutions because they quite like the idea of the international judges of particular repute being there. But I think that the ones that you mentioned in the Netherlands and Paris and Abu Dhabi and Kazakhstan, what's interesting is they're all choosing common law. So that's a real vote of confidence in the common law, which is unsurprising for international transactions. But I think it's a bit of a novelty. Kazakhstan wants to attract staff. My Kazakh friends tell me that that's kind of not happening. Why wouldn't the Netherlands and France take advantage of the uncertainty in England at the moment? But I don't see international clients saying, "Oh well," because arbitration continues to offer the neutrality. It continues to offer confidentiality of sorts. It continues the ability to appoint arbitrators that are expert in the law or the nature of the contract. It offers a degree of finality and the flexibility of procedures, and all those things an offer. And I don't think these courts are going to be a serious contender to that. As the monolingual person practicing in England, I just think it's great that I think the Swiss Federal Court, the rules will say that a challenge to the Swiss Federal Court can be made in English. I think the Netherlands are the same. I don't think it's the case in Paris yet. That is so international. I can't imagine it happening in England. So that's a very good offering if you're trying to attract the seat. But to your question, do I think the commercial courts offer serious competition now or in the medium future? No.
So what do you think in relation to the backlash that investment arbitration is facing, and whether do you think this may spill over to commercial arbitration? So is there a threat there from these developments to threaten seriously commercial arbitration as well as investment arbitration?
Well, I don't share this fear, but I completely agree with you with respect to the other fear. I think these international commercial courts don't raise any problem for arbitration. Interestingly, in Switzerland, in Zurich, and in Geneva, it's the prominent representatives of the arbitration community which push in favor of the establishment of such courts. They think the message should be, come to Zurich, whether it is for arbitration, whether it is for a commercial court, whether it is for small-sized or big cases, we can provide everything in English. They think there is a common interest, and commercial courts will help arbitration to keep its market shares, and no threat at all. The language issue, of course, is important. We have not yet the rule that you can appeal to the Swiss Federal Supreme Court in English, and it's rather difficult to find good Supreme Court judges who master English to a degree, not just as a working language, but really understand the subtleties. We have the patent court. There you can apply in English. But this is an issue for us, to provide a forum where you can plead your case in English.
Yeah.
And this would be an advantage of the International Commercial Court.
Alex, I know that the ICC takes a very close look into these developments, and I know that you have an observatory status with the ancestral proceedings, and you were there recently. And whether do you think, whether the ICC, what is the thinking in the ICC about the threat, the potential threat from investment arbitration discussions and the establishment, the potential establishment of a court system based, and whether these will spill over commercial arbitration?
Well, I think it's a little bit premature to speak of a risk or the inexistence of risk. I think ISDS right now is obviously in need of reform. We don't know exactly what form that reform will take. I think there's a benefit, and the benefit is that some of the topics that have been identified as crisis factors in ISDS have also now been, or have been for some time, been transmitted into the commercial sphere with some beneficial results. So we're talking about the transparency of the work of institutions, which I think is a great thing. Transparency in the pool of arbitrators, and inclusion and diversity, and a number of things which I think actually do come from the investor-state sphere, and I think are good. Now, whether any potential crisis in the investor-state dispute settlement system benefits commercial arbitration, I think in the short term, we do see that to a certain extent. We do see certain states that have either never ratified the ICSID convention or may have ratified it and may also have opted for bilateral treaty protection and have now gotten out of their bilateral engagements and have moved back into contracts. And commercial contracts will include arbitration agreements. And those arbitration agreements will not provide for ISDS, but they will provide for ICC arbitration or maybe LCIA arbitration or maybe Swiss chambers and so on and so forth. So there is a short-term effect, but we can't really speak about the future. And as you said, we have observer status at the UN General Assembly, so we're monitoring that, and probably we'll know a little bit more over the next couple of years.
Rodney was making exactly the same point last night in relation to a potential shift from the substantive protection at the ISDS level to contractual level. Do you think, have you seen that happening in your practice, in your hat as a lawyer in established law firm?
Yeah, certainly I encourage my transactional colleagues, if they have concession contracts, to try to negotiate into that some of the protections that you can find in an investment treaty. Easier to do with expropriation because it's quite hard, because most countries will have in their constitution some law against unlawful expropriation. So it's easier to say, well, why don't you put in a contract because we want arbitration in a neutral venue. I encourage, but harder to get FET or national treatment into a contract. But that all depends on negotiating power, and I think there will be a shift of some sort in that direction. Not a huge movement of the dial, but of some sort.
Christophe, a final comment on that point? If not, then I think I'm allowed to close the proceedings. It's been a long day. It's a very, very long day, but a very productive day. I want to thank again Professor Stavros very, very much for the organization.